In today's video, we're talking about a very serious crime in Arizona. It's called fraudulent schemes, also known as fraudulent schemes and artifices. This is a crime that involves some sort of fraud or misrepresentation where an individual or a group of individuals are doing something fraudulent. They're misrepresenting something. They're taking something that doesn't belong to them. There's some sort of deceit that's involved. It's a very, very serious crime in Arizona. So today we're going to talk about the elements of the offense, what the law says is prohibited. We'll talk about what the penalties are if a person is convicted. Then we'll talk about some common defenses. So let's first and foremost take a look at where fraudulent schemes is located under the Arizona Revised Statutes. It's under Section 132310, and this is the language of the law. This is not verbatim, but I've kind of broken it up so it's a little bit easier to understand. Let's take a look at what the law says is prohibited conduct, or what constitutes fraudulent schemes. So first and foremost, all of this conduct needs to be done pursuant to a fraudulent or to some sort of a scheme or an artifice. So this is some sort of a plan. This is some sort of thought out process or procedure that is taking place. A person needs to knowingly obtain a benefit. Doesn't need to be a big benefit, doesn't need to be a small benefit, it's any benefit. If they can find a benefit, it's going to meet this element of the law. Next, a person needs to have obtained that benefit by the means of one of the following: through a false or fraudulent, any one of these, false or fraudulent pretenses, false or fraudulent representations, false or fraudulent promises, or false or fraudulent material omissions. So a material omission would be when two parties or three parties or a group of people are entering into an agreement and something should be disclosed to them. Something should have been told or explained, but it wasn't. It was omitted, and it was material to the agreement. It was something that would have ordinarily been disclosed, and it wasn't disclosed. That would be considered a material omission. Same thing with pretenses. So pretenses are an idea of kind of what is under the surface. So it's an agreement between two people. It's based upon certain facts that would otherwise be considered to be normal or taking place. Those would be pretenses. If there's false or fraudulent pretenses, one party's believing something to be true when another party knows that it's not true. Same with representations or promises. These are just promises that are being made that aren't true. They're false or they're fraudulent, and there's a scheme or an artifice that's in place. It is important to note that the other party, so the person who's being defrauded, or the victim in this case, doesn't actually have to rely on any of these things. This is written into the statute. So a person need not actually have knowingly or as a matter of fact relied upon any one of these things. The fact that the defendant was actually just doing them, whether the other person bought into the false promise or actually relied on the false misrepresentation, doesn't matter. Just the fact that it was done is enough to meet the elements under the statute. So the penalties, as I said at the beginning of the video, are very, very serious. In Arizona, this is a Class 2 felony. It's essentially the highest level felony that we have under Arizona law. So at the most serious level of felonies, we have Class 1s. Those are at the top, the most serious. Class 6 is the least serious. It's at the bottom. Class 1 are really reserved for murder, manslaughter, or basically murder, first-degree murder. Anything lower than that is really what we're dealing with most of the time. So Class 2 is just one level below murder. It's very, very serious. So you can understand why this needs to be addressed appropriately. If somebody's been charged, if you or a loved one have been charged with fraudulent schemes, it's very important that it is addressed by competent defense attorneys. So let's take a look at what the sentences are. So if you look at the felony sentencing chart, you can go to a Class 2 and see. As I said, these are basically the most serious types of categories for sentencing that you can have under Arizona law. But it's important to note that prison becomes mandatory, meaning you can't get probation if the value of the benefit, so up here, if the benefit that was received by the defendant, if it's over $100,000, then there's no probation. It's prison mandatory. In other words, you have to go to prison. You have to fall within that sentencing range. Also, if it involved basically opioids, the manufacture, the marketing, the sale of any opioids, and there was some fraudulent schemes involved, then that is also going to be prison mandatory. So it's very, very serious. Now, when we're talking about the $100,000, the law allows us, or allows the prosecutor's office to aggregate the different penalties, the different amounts. So if there's a number of different transactions, say they're all small amounts or a couple $1,000s here, a couple $1,000s there, the law can aggregate those all into one, and they can reach that $100,000 number through aggregation. So you can get to that $100,000 pretty quickly. Some common defenses are listed here. There's really many, many more than these, but we'll just touch on a couple quick ones. So first and foremost was there's really no actual benefit that a person is receiving. So this part of the element, this part of the statute is not being met. The person who's being charged with the crime didn't receive an actual benefit. As I said at the beginning of the video, this says any benefit. So really, if the prosecution they can kind of really stretch this out to include anything, whether it was an increase of reputation or some other kind of related benefit. It may not be monetary in nature, but if they can tie it to any benefit, they may do that. In most cases, they want to tie it to some sort of monetary value. So if you can show that there was not any actual benefit that was received by the defendant, you may knock out this part of the law, this element of the offense, and in which case their case becomes much more difficult to prove if they can't meet this. The next big defense is that any benefit that was actually received was not due to any of the fraud or the misrepresentation. So in other words, any of the stuff that was actually happening didn't lead to the benefit. The benefit was received as a matter of the course of due business, or a person was approved to receive that benefit. And so any of this stuff that may have been going on didn't connect. There was no nexus between this part of the violation and this part of the law here. So that in that situation, the benefit could come from elsewhere. This is not what the statute is for. The statute is for basically punishing people who received a benefit due to some fraud or due to some false misrepresentation. Finally, or next we have the idea sort of related to the last one, that there was a mutual agreement between the parties. So there was a benefit being received, but it was a mutual benefit. So both parties, both the victim and the defendant, the person who's being charged with this, both agreed upon the fact that this was going to be happening. This happens a lot in business relationships or employer-employee relationships, where there was an agreed-upon benefit that was knowing that it was supposed to be going to that individual. Then the relationship sours, and then one party will report the other party and say, well, in fact, this person was doing this and they shouldn't have been doing it, when in reality that's not the case. There was an agreement. It was understood that this benefit was going on, and so any of this stuff sort of is negated by the fact that this was a mutual understanding. Both parties knew this was going on. And lastly, of course, there's a misrepresentation by the victim. So the person who's actually reporting this crime is just simply misrepresenting the facts. There was no false or fraudulent, or there was no false pretenses. There was no false promises that were happening. There's no evidence that any of this stuff was actually going on. It just kind of turns into a case of sour grapes. A business relationship dissolves, an employee leaves and is angry at an employer and reports them, and they make up all of this stuff. So in other words, there are no facts that show that there was any false or fraudulent scheme. There was no artifices going on. None of that was actually taking place under the facts of the situation that is being reported, and therefore it cannot meet this element of the law. So just a few quick defenses. As you can understand, when you're dealing with a Class 2 felony, there's a lot more that goes into this. You need to do a very thorough analysis. You need to complete very extensive interviews. You need to review a lot of financial data, and so it's important you have an attorney that you can trust. If you or a loved one has been charged with fraudulent schemes or artifices, give us a call. We offer free case evaluations. We'll have you come into our office. We'll sit down. We'll review the facts of your case. Make sure you have a plan moving forward. Thanks for watching.